Building upon the previous discussion of property management firms and rental agreements, it is crucial to distinguish between residential and commercial property management. While both are governed under Arizona real estate law and fall within the licensed authority of a broker under ARS Title 32. Chapter 20. The nature of the management duties, applicable statutes, and contractual obligations differ substantially. Understanding these distinctions is vital for licensees to maintain compliance, uphold fiduciary duties, and competently represent their clients within their scope of expertise as required by AAC R4-28-1101H and R4-28-1103A. Residential property management involves overseeing homes, apartments, condominiums, or multi-family dwellings where tenants reside for personal use. It is regulated primarily by the Arizona Residential Landlord and Tenant Act, ARS, Section 33-1301 ATSEQ, which sets forth tenants' rights, landlord obligations, notice requirements, and procedures for rent collection, security deposits, and eviction. A residential property manager's primary duties include marketing vacancies, screening tenants, collecting rent, handling maintenance requests, enforcing lease terms, and ensuring habitability standards are met under ARS, Section 33-1324. In residential management, the relationship between the landlord or property management firm and the tenant is often more personal and subject to consumer protection principles. For example, the property manager must ensure compliance with fair housing laws under the Arizona Civil Rights Act, ARS Section 41-1491 ATCQ, and the Federal Fair Housing Act, 42 U.S.C. Section 3601 to 3619, prohibiting discrimination based on race, color, religion, sex, national origin, familial status, or disability. Residential managers also handle security deposits according to ARS, Section 33-1321, which limits deposits to 1.5 months' rent and requires refunds or itemized deductions within 14 business days after a tenant vacates. For instance, if a residential property manager oversees a 10-unit apartment building in Mesa, they must maintain accurate tenant ledgers, process repair requests within a reasonable time, and handle all tenant funds in a designated trust account as required by ARS, Section 32-2174. If they fail to address habitability issues, such as a broken air conditioning unit during the summer, the tenant may lawfully terminate the lease or seek damages under ARS, Section 33-1361. Residential management requires attention to consumer rights, property condition, and timely communication. Commercial property management, by contrast, pertains to properties used for business purposes, such as office buildings, retail centers, industrial parks, or warehouses. These arrangements are governed not by the Residential Landlord and Tenant Act, but by ARS, sections 33-341 through 33-381, which outline landlord and tenant obligations for non-residential leases. Commercial leases are typically longer term, more complex, and heavily negotiated between sophisticated parties. Unlike residential leases, there are fewer statutory protections for tenants, as both parties are presumed to have equal bargaining power. Commercial property managers oversee leasing, rent collection, maintenance of common areas, compliance with zoning and building codes, and financial reporting for property owners. They may also negotiate tenant improvements, coordinate with contractors, and manage shared operating expenses known as CAM charges, common area maintenance. Unlike residential managers, commercial managers must understand triple net leases, NNN, percentage leases, and gross leases, as these determine how costs like insurance, taxes, and utilities are allocated. For example, A commercial property manager handling a strip center in Gilbert may be responsible for ensuring each tenant pays their proportionate share of CAM expenses while also ensuring lease compliance and tenant retention. If a tenant fails to pay rent, the manager must follow the statutory eviction procedures under ARS Section 33-361 and may pursue damages in court without the same consumer protections afforded to residential tenants. Another key difference lies in licensing and competency. Both residential and commercial property management require a real estate broker's license. However, commercial management often demands specialized knowledge of financial modeling, investment analysis, and lease negotiation. Under AACR 4-28-1101H and I, a licensee may not perform professional duties beyond their field of competence. A residential property manager without commercial experience should not attempt to manage a multi-tenant industrial complex without proper training or supervision. In addition, record-keeping and trust account management obligations apply equally to both residential and commercial property management, as outlined in Arizona Revised Statutes. Section 32-215-1.01 and Section 32-2174. However, commercial management typically involves larger sums of money and more complex accounting procedures, often requiring monthly owner statements and reconciliation of operating expenses. A useful illustration comes from Hancock v. Arizona Board of Realtors, 1995, in which a broker managing both residential and commercial properties was disciplined for failing to maintain separate trust accounts and accurate ledgers. The case reinforced the importance of financial segregation and compliance with statutory accounting requirements, emphasizing that even experienced brokers are held to the same fiduciary standards regardless of the property type. Review summary. Residential and commercial property management differ significantly in scope, regulation, and complexity. Residential management focuses on consumer protection, habitability, and compliance with landlord-tenant laws, while commercial management emphasizes contract negotiation, investment performance, and operational efficiency. Both require strict adherence to trust account rules, fiduciary obligations, and competency standards under ADRE regulations. A licensee must understand which legal framework governs each property type to properly represent clients and maintain professional compliance. Discussion prompts. Why do residential tenants receive more statutory protection than commercial tenants? Answer. Residential tenants are considered consumers with less bargaining power, so laws like the Residential Landlord and Tenant Act safeguard their rights, unlike commercial tenants who are presumed to be sophisticated parties. What fiduciary duty is most critical in property management? Answer. The duty of accounting, ensuring accurate handling of all client and tenant funds, in accordance with ARS. Section 32-2174. Why must a broker avoid managing properties outside their area of competence? Answer. Under AACR 4-28-1101H and I, a licensee must not perform acts requiring knowledge or expertise they do not possess, as this may constitute unprofessional conduct. Closing remarks. Residential and commercial property management each serve distinct sectors of Arizona's real estate market, but both require professionalism, legal knowledge, and ethical discipline. Successful management depends on understanding the statutes governing each property type, honoring fiduciary responsibilities, and maintaining transparent communication with both owners and tenants. A skilled property manager not only ensures compliance, but also builds long-term trust and profitability for their clients.